This is a petition for writ of habeas corpus that I'm working on.
Okay, I think we're ready. Here we go.
And so this is still a work in progress, but this is preliminary. Texas is under military occupation since 1861 when the U.S. Army invaded Galveston, Texas, as evidenced by General Orders 100, also known as the Labor Code, which was written by Francis Lever, a Harvard law professor, in 1863 as requested by Lincoln. Now, this could be used in any of the Civil War states, also in California, Arizona, New Mexico, also Utah, Nevada, that are all part of the Treaty of Hidalgo, because the Treaty of Hidalgo doesn't say anything about ending the martial law. So the rest of the southern states are it was treated as an insurrection, and so this is the Labor Code. Article 1, a place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. That's Article 1. General Orders 100, which is the Labor Code, has never been repealed and is now part of the United States Law of War Manual, a book about 4 inches thick. Matter of fact, I could bring in a copy. I've got a copy at home. The martial law continues to this day because there was no treaty of peace, just an armistice. In Texas case, there was no treaty of peace. In Arizona, there was a treaty of peace. It was called the Treaty of Hidalgo, but the Treaty of Peace has to make a special mention, and we'll read it here in a second, because there's been no special proclamation by the Commander-in-Chief and no Treaty of Peace in Texas case. Article 2 of the Labor Code, martial law does not cease during the hostile occupation, except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war. Okay, so they gotta say that the martial law ends. That's why you see military police in California and Arizona and New Mexico. They're all military police. In Texas case, President Andrew Jackson officially recognized the Republic of Texas on March 3rd, 1837, which is also recognized by France, December 25th, 1839, and other nations, including Belgium and the United Kingdom. And the intervener, okay, and that's should be changed. In this case, it's the petitioner. We can probably just take that out. I was using this to file a notice of intervention. The fact that the Republic of Texas existed is beyond dispute. And this is a book called The Law of Nations by Vattel, Book 1, Chapter 1, Section 1. A nation or a state has been said at the beginning of this work, a body politic or a society of men united together for the purpose of promoting their mutual safety and advantage by their combined strength. And there is no definition of how many people are required to constitute a nation or state. And this is Article 1 of the 1933 Montevideo Convention on the Rights and Duties of States. The state, as a person of international law, should possess the following qualifications. A permanent population. B, a defined territory. C, a government. And D, capacity to enter into relations with other states. And the Republic of Texas qualifies for all of that. And all of the inhabitants of the territory properly included within and rightfully belonging to the Republic of Texas are entitled to the same protection of the law. And this is Article 9 of the Montevideo Convention on the Rights and Duties of States. The jurisdiction of states within the limits of the national territory apply to all the inhabitants, nationals, and foreigners are under the same protection of the law, and the national authorities and foreigners may not claim rights other or more extensive than those of the nationals. The state of Texas joined the Confederacy and Union. In 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress at 9 Stat 1, which and still exists as evidenced by House Joint Resolution 1, dated 29 December 1845. Quote, the territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the State of Texas, on an equal footing with the original states in all respects whatever, with the Republican form of government as found in the Act of Congress, December 29, 1845, at 9 Stat 1. And this is the preamble of that act. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that the laws of the United States are hereby declared to extend to and over, and to have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. And in House Joint Resolution 1, dated 29 December 1845, 9 Stat 108, whereas the Congress of the United States, by joint resolution approved March the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the State of Texas. And it resolved and admitted into the Union on an equal footing with the original states in all respects whatever. So they're talking the original states, the original 13, under the Articles of Confederation. Because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation, let me just look here real quick. Okay. So a proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under the Articles of Confederation and Perpetual Union, 1781, under Article 9. Canada ceding to this confederation and joining the measures of the United States shall be admitted into and entitled to all the advantages of this union, and no other colony shall be admitted into the same unless such admission be agreed to by 9 states. That's Article 9 of the Articles of Confederation and Perpetual Union, 1781, which means a House Joint Resolution is all that was needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas. The territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced by the state of Texas, and the Republic of Texas still existed in abeyance or dormancy. I'm not sure if this is important to put it in there, but it should be the petitioner anyways, no matter what. I'll have to think about whether I want to put that in there.
Glenn, is this one of your court cases?
This is a petition for writ of habeas corpus that I'm working on. I'm thinking about filing it on behalf of some people, Jim Tessie for one. Seems to the petitioner that for the state of Texas to join the Confederacy under the Articles of Confederation and Perpetual Union with a House Joint Resolution is perfectly fine, but the preamble of the Act of Congress, 9 December 1845 at 9 Stat 1 says Texas is admitted into the Confederacy and Union of the United States. Which is, sorry?
What year was that?
1845.
Yeah, 9 Stat 1, which is also talking about the Union under the current Constitution, which was in place in 1845. And Article 4, Section 3, Clause 1 requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done. The state of Texas failed to replace the Republic of Texas, and the Republic of Texas that was recognized by Andrew Jackson still exists, and recognition is unconditional and irrevocable under Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States that was acceded to by the U.S. Senate as a treaty. And I need to add this in, actually. So that's paragraph 10.
You might add too, Glenn, that the president had to be the one that would declare it unrecognized. And that never has been done after Andrew Jackson did it.
They can't unrecognize it, Darren.
Once it's in, it's in.
Sorry?
Once it's recognized, it's in. It's done.
Once it's recognized, it's recognized. They can't unrecognize it.
Yeah.
Okay. So Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934 at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. This Constitution, laws of the United States, which should be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. The military occupation is illegal and unconstitutional under the 1933 Montevideo Convention on the Rights and Duties of States that was ratified as a treaty. The territory of a state is inviolable and may not be the subject of a military occupation. It's Article 11.
Under what again?
The 1933 Montevideo Convention on the Rights and Duties of States, which requires, quote, the territory of a state is inviolable and may not be the object of military occupation. The state of Texas is a military dictatorship put in place by the U.S. Army. The current Texas Constitution and all Texas statutes, codes, rules, and edicts are edicts under martial law as found in Article 3, General Orders 100, the Labor Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government of the occupied place or territory, and in the substitution of military rule and force for the same, as well as the dictation of general laws as far as military necessity requires the suspension, substitution, and dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the command military authority. Bottom line is, it's all edicts under martial law. It's a dictatorship. The indictment, this is actually a habeas corpus that I'm working on for someone that these two cases, 1847275 and 190000230 in the 45th District Court, are all edicts under martial law and unconstitutional pursuant to the 1933 Montevideo Convention on the Rights and Duties of States and the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. That's Article 6, Clause 2. The common law is the law of the land, which was here before the government, and that's found in Hill versus Hinkle. The petitioners failed to commit any common law crimes. For all the foregoing reasons, the indictment/criminal complaints, all warrants and charges should be quashed, and this case should be dismissed. And I got to change that. Anyways, so I'm working on this still. So this is for someone by the name of April Rose Schoppel, and it's by me as next friend. Okay, that's how you do a habeas corpus. I got to get a habeas corpus because I know there's some other forms that go along with it. There's a summons for the county sheriff to show up. Anyways, yeah, that's my habeas corpus. It's one I'm working on. Huh?
That's good.
Well, I think it pretty well nails them down. I don't know how they can weasel out of it.
There's no wiggle room because you got them on all angles. If they say there was an agreement, they can't provide it. The Senate walked out, there never was any signature. And we know that Andrew Jackson recognized at some point, and once that's done, it's in.
Once
So,
recognition is irrevocable and unconditional.
uh-huh.
So they can't sit there and say, well, something, whatever they want to say. I don't see how they can make those arguments. So I guess we'll see. It certainly, I think this can be used in any of the southern states. It could be used, it's going to be modified a little bit, but this argument is sound. You could use it in California, any imprisonment, anybody in prison in any of those locations, federal or state, it wouldn't matter.
Why is it just those 7 states?
Well, the other ones are going to be hard to prove because, like, if the state is like Ohio, okay, because you got to prove a military occupation. It's easy to prove a military occupation in Texas because the Union Army invaded Texas, Galveston, Texas in 1861. That's well documented. But was there a Union Army invasion of Ohio? I'm not sure. How do you prove that?
I'm not sure either. But they did invade also New Mexico.
Oh, yeah.
Where?
I heard that they came in, U.S. troops in New Mexico.
Well, I know. That's what I said. In New Mexico, all the southern states,
Yeah.
New Mexico, California, Arizona, Nevada, any of the territory involving the Treaty of Hidalgo. Because the Treaty of Hidalgo was, and parts of New Mexico were parts of Texas at that point. I was arrested on the east side of the Rio Grande in Albuquerque. I was arrested at the Crown Plaza Hotel. That's Texas.
Texas, you were so lucky that they came. They did it in Texas.
They arrested me in Texas.
Yeah.
Oh, it was well.
He
it
just
is
barely in Texas.
No matter, you were there.
I was on the east side of the Rio Grande River. That's all that matters.
Yeah.
And so, anyways, so we'll see. That's all I can say. I think this argument is really good, and I'm going to start using it. I think that we can start getting people out of jail using this argument. But every state is going to have to be a little bit different. If you're in Treaty of Hidalgo territory, then you just got to bring up the fact that the Treaty of Hidalgo doesn't have a specific mention of a treaty of peace or of ending the martial law.
Right. And what year was that treaty? Hidalgo.
It was like the 1840s, so it's before the Civil War.
It affected 7 states.
Treaty of Hidalgo affected part of what's now New Mexico, Arizona, California, Nevada, Utah, parts of Utah. I'm not sure. Might have been all of Utah. And I don't know, maybe some in Colorado. It's hard to say.
Mm.
But and then the Civil War affected, the southern states, and so it would affect any of those states. You could easily prove those ones. You got to be able to prove that you're under martial law. I mean, the evidence is all over the place. You have military police, there are military uniforms, there are military rank structures. You're under martial law, but you can't just say that. And you got to be able to say something in history that happened that caused this to happen. You see what I'm saying?
Yeah. I think Tennessee's in that too.
Sorry?
I think Tennessee is in there too because we have.
Of course it is. It's one of the southern states.
Yes.
And if you tell them and they don't correct it, shame on them.
Well, under the Montevideo Convention, they have to make the law the same for everybody.
That's correct.
And so they can't sit there and once you tell them, they can't sit there and play stupid.
Stupid, yep, they can.
Anyways,
Bend them over, buddy.
so that's basically what I wanted to talk about today. I think this is like really powerful. It's going to be still a work, some work on it. I need to do some more work on it as far as before I file it. There'll be some stuff that I'm not sure that I want to even put in there.
And you've got to keep it to 40 pages.
Well, it's way less than 40 pages. It's like 5 pages right now, 6. Then with the certificate of service, it'll be 7. So it's way less than 40 pages.
And that's better anyways.
And a habeas corpus, I don't think there's a limit, although it's good to keep it short. You don't want to be spending a lot of time putting a lot of stuff in there. Like when you're doing an appeal, like the Supreme Court appeal that I have to do has to be kept to 40 pages. And I already sent that to them. I went there with Ken on Sunday. The post office in Dallas is open on Sunday.
Was that the Bulk Mill Center?
The where?
Which post office? Is it over on Hampton Road and 30?
It's, on 30. It's the main post office.
Okay, they're open on Sundays.
Yeah.
Okay.
Yeah. Yeah, they weren't open yesterday. There was a sign in the window saying we're not going to be open on President's Day, but they were open Sunday.
Do they postmark it on Sunday too?
No, sorry.
Okay, like if you bring something in, will there be a postmark that it was
Yeah.
mailed on Sunday?
Of course they will be.
I've been mailing stuff from there for 40 years.
I don't see any postmark.
It used to be open 24 hours a day, 7 days a
Right.
week.
Well, I remember that. I thought
But
it changed.
but they did change. They did change. But they're still open on Sundays. They're open 7 days a week except holidays.
Okay. I used to go there middle of the night and get stuff mailed out. But
Yeah.
But they don't do that. But at least they're open on Sunday now.
Yeah, they close. They close during the week. They're open till 10 o'clock at night.
Okay.
Yeah, and there's one in San Diego that used to stay open until midnight. The main post office down on Midway.
There used to be post offices in every city, in every major city that was open 24 hours a day, 7 days a week. I used to go, there was a San Antonio post office that was open 24 hours a day, 7 days a week. But the Congress has been putting a lot of burdens on the post office, and so they're cutting back. And so they're not open 24 hours a day, 7 days a week anymore.
Well, I hear the budget, although I don't know how that could be because I can hear the budget's been.
Well, it's just fictitious money anyway.
Right.
At any rate, so I think that this is a.
You did your homework. You put a lot of time and effort into
I think this is a really powerful argument, and I think that we can. I want to use it. I want to try it with. Well, if Jim wants to do it, then I'll certainly help him.
it. You liked it.
I think it's brilliant. It just dawned on me recently to try this, to do that, because I had done a notice of constitutional challenge into that federal case. And so so they knew. I think that they're jerking my chain. I think they're playing me in the federal court. I think they want me to bring this action. They want me to bring up this issue. I think that's what's going on.
You do.
Yeah, they want me to bring it up because Texas is under military occupation, and get the Supreme Court to say, yeah, it's unconstitutional. It's time for it. You know, Scallion said that the United States would break up and Texas would be the first to go. And all the Supreme Court would have to do is say Texas military occupation is unconstitutional and the Republic of Texas still exists. Matter of fact, Texas joining the Union was unconstitutional too.
Does that extend into Louisiana?
Parts of it, there's very small parts of it. I'd have to you got to look at those old treaties and see, you know, because original Republic of Texas goes all the way up to Cheyenne, Wyoming. You know, it goes up through Colorado. It's to the Rio Grande River. So everything east of the Rio Grande is Texas.
Yeah, and then you got a little bit of Louisiana because there's a signpost that in Louisiana.
There is. I know.
It says
It says-
Texas and
It
it's in Louisiana.
Yeah.
It's east of Nacogdoches. If you go straight east, there's a sign.
Yeah, I think it's a sliver of land. It might be
Yeah.
because the river changed course or something.
The Sabine River may have changed.
Yeah.
Yeah, because that's where I got a chicken in Louisiana, so I'd like to have a big.
Anyways.
To Quincy.
Anyways,
Well, it would be very little bit of land, so I don't think you're in Texas then.
Uh-huh. Let me see where the Quincy is.
anyways, I just wanted to bring this up.
Did you bring up the fact that they arrested you in the land of the Republic of Texas?
I did, of course.
To make sure, I figured you would.
And that I'm a senator, and that I have immunity from public statements, and under the Articles of Confederation, and that I was in charge of the affairs, which means I have diplomatic immunity there too.
It's right under, Supreme Court.
Well,
Yes.
if you look at Nacogdoches and go straight east,
So, anyways, I suppose that's it. I'm going to end this live stream and end my.
Nacogdoches.
Okay.
And there's nobody on my live stream.
It's just a little bit.
Looks like there's about 7 viewers, but nobody chatting.
I can see that.
One thing that we need to tell them is the truth, the whole truth, and nothing but the truth.
There you go, Carrie.
When you tell them that, if they violate the truth, the whole truth, and nothing but the truth, and the truth is anything that they don't correct, break it
Yeah.
off.
Well, that's what he does. I think he gets 30 days.
Right, but I'm just
You know,
telling
you need to tell Twyla to give him vitamin B12.
Okay.
because I just know that when one time that I got into trouble, I told him, I said, "Is it, Your Honor, is this about the truth, the whole truth, and nothing but the truth?" He said, "Yes." Okay, so help me God? He said, "Yes." I said, "Then you define God." And I sat down and the judge went just like this. Blah, 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 blah. He said, "Dismiss." He couldn't because,
Is that right?
yeah, well, the problem
The
is
state can't get involved in it.
they can't get, well, the problem is
Can't define who God is.
that's correct. You got to define it. And see, what my strong suit is I make them define everything.
Yeah.
See, and the definition can be, for an example, I'm from Michigan. We say "you guys." What do they say in Texas?
Yeah.
Oh, so your lips said "y'all" and "you guys" are the same. Is that what you're saying?
Yeah.
That's not true.
She's
Y'all.
she's from Tennessee. We all say from
I'm
Tennessee.
from San Diego.
What do they say from San Diego?
You all.
Did they do you all there?
Yeah. Well, see, but y'all and "you guys," is it the same? What about women?
We say you guys.
Yeah, but what about women?
Yeah.
See,
Yeah,
see,
that's good.
See, so now there's a problem. But that's parochialism. Oh, okay.
Define parochialism.
That's right. See, so now we ran around the mulberry bush for about 2 hours, and the guy said, "Just let him go." He said, "He's costing us too much money." I just left. The problem.
Damn the bad luck, eh?
Yeah. See, the problem is, like the judge said, I'm an asshole. That's what he told me. I said,
Well, let me tell you, he is. The asshole is the judge, not you.
Well, I don't know about that, but see, anytime if I get pulled over by the police, he writes me a ticket, I'll ask him a question, because then what happens is, when we go to the court, I'll say, well, he said this. See, I'm gonna have to, because I gotta establish my, argument. Don't just sit there and don't say nothing. So will I speak? Yeah, compared to what?
Yeah, really.
I mean, I'm confused compared to what?
See, every word
That's
he
correct.
thinks about.
Okay, I'm signing off on this live
And
stream.
he'll when someone says something